Hi, my name is Malus Mkize, and today we're just going to be looking at really the conclusion of what we've started with this whole topic of business assurance. Now, when we started out with the whole case of Mr. Green and Mr. King, we identified initially four different needs, but we're going to leave out the personal need since our topic is business assurance, and we're going to focus on the tax treatment, specifically estate duty treatment of the proceeds that pay out, whether it's a buy and sell agreement or from proceeds from a key individual policy or a contingent liability plan, and what are some of the issues that are involved in around structuring, making sure that the policy does form part of deemed property or whether it will not form part of deemed property. So let's have a look at that. Now, following from the quote from Mayor Witt that you just saw, I think it becomes clear that the end result, if the law is not written in very clear terms, and even worse in this case, there's not even cases where you could say, well, they decided this case in this manner, so therefore this is how we interpret the provisions. But this leads to difficulty in interpretation of the actual law to begin with, and then obviously the practical application of the law. I'll show you what the provisions look like, and just to try and water them down. But I mean, I do go over in the dissertation, which I'll put a link down to below, in terms of going to drill down at exactly each provision, each requirement, what are some of the pitfalls that could come through, and how do we advise clients to say, okay, well, what are the chances of you or the policy process becoming deemed property or not becoming deemed property, so we can plan ahead as best as we can. So that's what we're trying to do. So this is what the provisions look like. I've just really snapped this out of the act, and I'm trying to zoom in. At the bottom here, which I'm trying to highlight, is the buy and sell exclusion provisions, and on the top here is the key individual one. And if I just try and zoom in on the key individual one, for example, just to give you an idea, sorry about that. So let's just try and read it. I mean, I'm not going to go into detail. So it says, except where the provisions of paragraph 1 or I or IA of this proviso apply, the commissioner is satisfied and remains satisfied. So, I mean, without even reading the rest of the provision, which is quite wordy, you know, when it comes to practice, you know, how do you satisfy a commissioner on something? You know, you've got to show some proof. And this is the space that we get into, really, where we're trying to say, well, we don't know what the commission is going to ask for in order to be satisfied, because the provisions don't spell it out. But however, based on how we interpret the law, this is how we can guide you. So that's what the dissertation goes into detail about, in terms of structuring the policies, just to look out of those pitfalls, to look after those pitfalls. But what we're going to do is, because the dissertation is very long, and goes into detail about the actual interpretation and practical challenges in applying these sort of provisions, I will water this down, obviously, the best way I can, so that we can at least have a point of reference. And for further discussion, by all means, as I've said, I'll put the reference of the dissertation below, that will go into far more detail about the different pitfalls that we face. So I think before we get into exclusions, I think it's just good to position what estate duty is. You know, why are these exclusions even relevant? So perhaps just to quickly summarize, So in South Africa, there's a huge disparity between the rich and the poor. Now, in terms of trying to manage the big gap, or to narrow the gap, you could perhaps raise taxes, income taxes, or company taxes, and that kind of stuff. But there's only so much you can raise. So what the government has said is, look, we want to have some sort of way we can raise revenue. And one of the ways we can raise revenue is through the wealthy. So, for example, estate duty deals with the fact that there's a transfer of wealth upon the deceased, the date of death. So we want to tax. So let's say, for example, the deceased estate is worth 10 million rands. As that wealth transfers from the deceased to whoever the heir is, we want to tax that portion, because we cannot raise more taxes anywhere else. So therefore, we need to raise taxes via the wealthy. So that's how the argument goes, and there's very good arguments to and for and against, but that's not why we're here. The point is that we do have a system of wealth taxes. In some countries, it doesn't, so we have to analyze how we actually manage this wealth tax for our clients. So in a nutshell, the nature of estate duty really falls in the bigger topic of the taxation or transfer of wealth. In some countries, they don't even have death taxes; they just call it some sort of tax upon the transfer of wealth, just like how I've just explained how estate duty is. And just to maybe simplify it, just to position things at a very high level, there's basically two. So some taxes you pay whilst you're still alive. So for example, you look at things like your donations tax. So for argument's sake, if while you're alive, you make a donation of, say, 1 million rands, now that means you are impoverishing your own estate by the value of 1 million rands, so that by the time you die, we cannot collect, or you cannot tax estate duty on that 1 million rands, because you've already donated to somebody else. So therefore, donations tax while you're still alive, you can be taxed by reducing via donation your own estate to some in favor of somebody else. Could be an entity, a person, could be whatever it is. And the next one that we could possibly bundle under taxation of transfer of wealth that could happen when you're dead or alive is CGT. So it's CGT. So for example, CGT, basically, if I have an asset and I want to sell that asset to somebody else, the purchaser, it's moving from my estate. And then with that move, with that disposal, we're going to calculate how much capital gain I've made and then include that into my income and tax some portion. So that, again, the point is, I've got a bit of wealth, I've made this transfer, and we want to tax a portion of that transfer of that wealth. And again, things like CGT can happen when you're dead or alive. I mean, CGT, you can pay CGT when you're disposing of your own property, or CGT after your death, if there's a capital gain perhaps made whilst your estate has been wound up. The estate might be saddled with their estate duty liability. And on the other hand, when we look at when you're passed on, so when you're dead, this is where estate duty comes in. So just like I've explained, estate duty tries to tax the net estate. I mean, it's obviously a whole calculation, but the net estate that is going to be transferred to whoever your heirs will be. So for the reason for that quick snapshot of just generally the topic of the taxation of the transfer of wealth is now the exclusion will start to make sense. So if I had to summarize, and of course I'm reading into the legislation just to make it easy for us to package. If you look at the buy and sell agreement clauses or provisions in the Act that cause the process to be excluded from the estate duty net, they really are meant to try and run away from double taxation. And through the example of Mr. King and Mr. Green, we'll see exactly how that pans out. And perhaps you could argue on the other side of key person or key individual policies that the exclusions are important, because we want to keep businesses alive for legitimate reasons, and because it's important for the economy to grow. But at the same time, we want to close certain loopholes from people trying to structure their affairs so that the proceeds are included. If, for example, the company is a family company. Otherwise, people could structure things that everything is based on excluded proceeds via key policies so that they transfer that wealth without attracting any state duty. So let's have a look at that. So in terms of a quick recap, we know that Mr. King passes away. So he's missing from his family. So this is where we draw the line. So this is with regards to his family, because he's a family man. But you'll see that, remember, he had a house. And although we're talking about business assurance, which is in this space, you'll notice that some of the activities, if you go back to one of the videos that we did, that the activities of his business through the loan that he made and using his house as security does affect his family. Anyway, so he's missing as a shareholder up over there. And we said he's missing also as a chief programmer. Now, he had policies put in place to try and solve or mitigate some of the risks that we identified in the previous videos that we went through. Now, in terms of the buy and sell policy, this is the need that we identified, and have a look at the video if you're not sure what I'm talking about. But we identified that a buy and sell agreement is in order, and a policy was taken. And now, again, I must stress this: different facts will vary. I'm just putting out there a very simple solution so we can have a point of reference for discussion. With different clients, it obviously will vary. So the policy stood this way. The owner was Mr. Green, who's the person that needs the funds. So he's taking out a policy on Mr. King, who's the life assured. And then the payer on the policy is Mr. Green, and the beneficiary is Mr. Green. Again, emphasizing the point that it is Mr. Green that needs the funds on the death of Mr. King so that he can buy his 70% shareholding in the company. Now, the reason I've highlighted Mr. King as the life assured is because estate duty is not driven by who the owner, payer, beneficiary, or whatever under the policy. Estate duty is payable on death. So we always follow whoever the life assured is, and that's where you calculate the estate duty liability. We always focus on whoever the deceased is, because it is upon the deceased death, that date of death, that some wealth transfers. In this case, the 7 million rands policy that Mr. Green has taken on his life. So hence, Mr. King is the trigger for estate duty. Now, Mr. King has passed away. Now we need to calculate his estate duty liability. So in terms of the estate duty liability, and I'm not going to go through the whole entire calculation as this is not the focus. The focus is whether the policy proceeds should become part of deemed property or they should be excluded entirely. So if we look at the estate duty calculation under property, I think we said the house was worth 3 million rands. So we're going to put 3 million rands up there. That is his property. Now, when it comes to deemed property, the whole emphasis is that although the property it is not around by the time that Mr. King is alive, it becomes a deemed property because it comes into existence. The 7 million rands payout becomes into existence upon his death. So although it's not a true property in a true sense, and there's a definition of what property is in the Estate Duty Act, but we deem it to become a property because it is a transfer of wealth to somebody else. In this case, Mr. Green, who's going to be entitled now to purchase the shares of Mr. King. So therefore, because it's a deemed property, we could put it down here as 7 million rands as a deemed property. However, a very important thing I haven't spoken about yet is the actual shares themselves. Now, those shares are worth 7 million rands. Now, those shares, in terms of the Estate Duty Act, are an asset. So they're going to have to be falling under not deemed property as the policies, but they're going to have to fall under proper property. So they're going to have to reflect under property as an actual asset that he had before his date of death. So therefore, we're going to reflect the shares under property, and they are worth 7 million rands. Now, here's the problem that I was talking about. This is why the exclusion exists. Although we know that we're trying to tax the transfer of wealth, but this is why the exclusion exists. if you look at this calculation right now, we're saying that property, he's got a house of 3 million rands, then you've got to add shares that are worth 7 million rands. That gives you a total value of property alone of 10 million rands. Now, because we know there's a transfer of wealth via the policy of 7 million rands to Mr. Green, we should add that as 7 million rands as a deemed property. However, the problem here for Mr. King is that this will create a double taxation, because in actual sense, if this buy and sell agreement goes through, this 7 million rands will be payable into his estate so that he purchases Mr. King's shares. But however, he has actually lost the shares because he's actually given them to Mr. Green. So it's almost like, well, not almost like, he swapped the 7 million rands proceeds for the shares, and the shares no longer are in his estate, and they actually belong now to Mr. Green. So now, in order to prevent this double taxation, you remember that when I showed you earlier on that there are provisions or certain requirements that must be met, because you can't just say, well, yeah, we're going to exclude it because, well, it was for a buy and sell agreement. You're going to show certain conditions existed, and that's why those provisions in the Act exist, because ultimately you're trying to prove to SARS that there was actually a swap here. Instead of me having been taxed for the actual assets of the shares and being taxed on the policy because there was a transfer of wealth to somebody else, well, ultimately what's happened is I've swapped my shares for the actual policy process, but certain conditions have to exist to try and show that this transaction actually existed. So what I put up on the slide now is a very watered down version, just to trigger conversation, of what the buy and sell exclusion looks like in terms of Section 33A IA of the Estate Duty Act. So it's just to trigger thought, and we can always, obviously, a lot of people obviously will try and avoid where possible the payment of estate duty. And it's important, number one, to structure the policies properly so that they talk to the exclusions in order to make sure that the property does not, the policy process does not become part of deemed property. So if you look at our example, we know that Mr. Green, the way we structured the policy, by the way, in this example, we structured it so that it avoids being included in deemed property that's attracting estate duty. So how we've structured it is that the owner of the policy is Mr. Green, life assured is Mr. Green, payer Mr. Green, beneficiary Mr. Green. Now, if you cast your eyes on the right of your screen, now these are the exclusion requirements. The first one, in order for that double taxation not to take place, is that the policy was taken out by and payable to a partner, co-shareholder, or member in a CC in the business. So now we know that Mr. Green is a co-shareholder in Zimele Pty, so we've passed that requirement. So, and he's the person that's actually taken out the policy, so that the requirement is passed. The second one, and all of these requirements must be passed. And the proceeds are used to purchase the business interest or shareholding and claims. Now, in terms of buy and sell agreement, when whoever the insurer is pays the beneficiary, in this case Mr. Green, he cannot just buy a Ferrari with that 7 million rands or whatever the case may be. He has to use those proceeds to actually purchase the shares from Mr. King's estate. Because remember, we're trying to avoid that double taxation, but we've got to show to SARS that this swap is actually in fact happening. So the proceeds must be used to purchase the business interest. The second thing is that if Mr. King had any claims against the company, whether it be the fact that he loaned the company cash or whatever the case may be, let's say maybe at some point Mr. King loaned the company 100,000 rands. Now, when he's passed away, his deceased estate has a claim of 100,000 rands against Zimele, the company. So when Mr. Green purchases his shareholding of 7 million rands, he must purchase also any claims that his deceased estate might ever have against Zimele. So therefore, in our case, it was simple 7 million rands, but let's assume that 100,000 rands that Mr. King had loaned the company and could claim, the deceased estate could claim that 100,000 rands from Zimele. Then the policy that would have been sold would not be the 7 million rands only, but the claim as well. So 7 million rands plus 100,000 rands. So that will be the full purchase, the full policy value that would be covering Mr. King. And then the third requirement is that the premiums are not paid by the deceased. Now, again, we've structured it so that it avoids falling deemed property. We know that the payer on our policy is Mr. Green. So that avoids it falling into deemed property. Perhaps what legislation is thinking of here is, you know, if Mr. King, nice guy, he could, let's say he's got very short time to live or whatever the case may be, and he could purchase a policy which is huge and literally drain his estate so that the proceeds get seen as a buy and sell agreement, but then they were actually funded by him. In other words, draining his estate so that when ultimately estate duty becomes levelable, it's on a reduced estate. So therefore, we don't want, SARS does not want the proceeds, the premiums to have been payable by the actual deceased. And in the case, we've structured it so that Mr. Green pays the proceeds. Now you'll see, which I won't cover in this example, there's some cases which I'll cover in another video where the payer, especially when there's more than 2 shareholders, when there's 3 or more, the payer could be the company just for the sake of convenience. And then I'll do a video on that and what the issues around that and how to structure it properly. So now in doing our calculation properly, we know that in going through the requirements, this policy is excluded from deemed property because it met all of the requirements. However, the shares here, very importantly, always remain as property. So they'll always be reflected as property under the deceased estate. And here, the buy and sell agreement, there's perfect exclusion, it met all the requirements. So policy 1, we've got 0. Now, we also know that Mr. or the company has taken out a key person policy on the life of Mr. King. Now, because Mr. King has passed away, it doesn't matter what the owner of the policy is, or it doesn't matter what the purpose of the policy is, we've got to figure out if these policies become part of deemed property or not. So in terms of the second policy, we know that the owner of the policy is Zimele, Mr. King is life assured, the payer is the company, and the beneficiary, who's the company that needs the funds to try and find a replacement for Mr. King, is the person that's going to receive the benefits. Now, if you cast your eyes to the right, these are the exclusions, or these are the requirements that must be met in terms of section 33A2. So if you look first, if you have a look at the first requirement, is that the deceased must not benefit, or the proceeds of the policy, the keyman policy, must not benefit the deceased estate. So in this case, we know that the benefits is benefiting Zimele, which is the company. So that requirement could arguably be said to have been met. So, and then the next one is that the proceeds must not be utilized to benefit a relative of the deceased. Now, if you have your word from the company Zimele that they're not going to take the funds and, you know, behind the scenes benefit any relative of the deceased, which in our example is Mr. King, then that requirement could be met. So, well, the policy was taken out for the purpose of keyman, so that could be met as long as we have their confidence. But the tricky part is, remember how the section opened up? It said the commissioner must be satisfied and remain satisfied. So even if you do this stuff in the future and SARS picks it up, it could be argued that this requirement is not met because the commissioner does not remain satisfied. So look at the next one. Making assumptions again that the proceeds won't be utilized to benefit the dependent for his maintenance upon the deceased death. Again, it's going to benefit Zimele here. The last requirement on this portion is that it must not be a family company. And in this example, this requirement will not be met. Now, one of the definitions, or not one of the definitions, but part of the definition of what a family company is in terms of the Estate Duty Act is that the shareholding cannot belong to one company. Now, you remember in our example in Zimele, 70% of the shares belong to Mr. King and 30% belong to Mr. Green. So straight away, just based on shareholding, which is a simple example, this makes this a family company. And again, like I mentioned earlier on, SARS could be trying to say, well, we'll exclude these proceeds, but we also want to make sure that people do not create companies and try and pass on wealth through key man policies and just create companies that say, oh, that this person was a key person, and therefore let's exclude the proceeds from deemed property, because that just could create a loophole. Remember, the other thing is, once those funds are sitting in there, companies don't die, so you can never charge or levy estate duty on the company. So those funds are gone for good. So that's a bit of a loophole that I suppose SARS is trying to capture. We've already failed the fact that this is a family company, so we don't need to go on any further. But just to demonstrate, it also goes on for the exclusion to apply that the policy was not taken or initiated by the deceased. In this case, very tricky to prove, and this is the stuff I go into detail with in the dissertation, because if he's 70% shareholder of the company, when those resolutions get passed for the company to take out a key man policy, whether it's on his life or not, he's involved. And in this case, it's obviously on his life. So it's very tricky to try and prove that he did not initiate the policy. But nevertheless, we failed the family requirement anyway. So it would be not necessary to continue. The fact that the premium must also not have been paid by the deceased, in this case, the company is paying for the premium, although it, again, arguable whether it's purely the company that's paying for the premiums, but that's a debate for another time. But for now, let us presume that that requirement is met. But can you see how everything can go this way or that way? So it's just really important to go through each requirement to make sure that things are structured correctly. But of course, the summary is just to trigger that thought. And then in terms of the last policy, we'll remember that the company had taken out a contingent liability plan because Mr. King had made a loan at the bank in order to fund the starting of Zimele. So on his death, in order for the bank not to chase that loan amount from Zimele, I mean, if they found not to be able to pay that loan back, then the bank could attach Mr. King's house, and he has a family. So in order to avoid that, the policy was taken out where the company takes out the policy, Mr. King is the life assured, and Zimele, once they receive those benefits, we remember in the previous video, there will be a contingent liability agreement between Mr. King and Zimele that it ensures that on the death of Mr. King, that the company actually utilizes those funds to settle the loan so that the bank doesn't have to chase the house. So in terms of the exclusions, straight away from the first exclusion, you see that if those funds are used to benefit Mr. King's estate, because if the funds are used to release Mr. King's estate from the obligation of paying the loan back to the bank, therefore it's benefiting his estate. So straight away that requirement has failed. Therefore you don't need to go on further to instigate or to check out the rest of them. Now going back to the actual estate duty calculation, we know that the second policy, which was for the key man policy, which was with I can't remember if we put a figure, but should we just call it 3 million rands? Did not meet all the requirements to be excluded. And then the third policy, which is for the house, which is a contingent liability plan, was for 3 million rands. So that's a total of his deemed property, because all of those requirements were not met. So let's give you a total of 6 million. Therefore, his gross estate is going to be that value of 6 million, and then you add it to this 10 million rands here, which is the total of his property, and then giving you a gross estate value of 16 million rands. Now, it's important at this stage that although we're not focusing on the deductions, we're just focusing on deemed property, these two policies here that did not qualify for these requirements, they will later on qualify after doing your gross estate. They will qualify for a deduction. And that deduction is whatever the premiums were payable, total premiums paid under these two policies for the duration of the term. So, for example, before Mr. King passed away, let's say the total premiums till the date of death were 100,000 rands. And the total payments of the policies over here were also 100,000 rands. That means because of these policies not meeting the exclusion requirements, that will become a deduction of 200,000 rands under here. But that's for a discussion for another day. Now, the important thing is the deemed property provisions, because we met all the requirements for buy and sell agreement, it is not included as deemed property. Because for key person and the contingent liability, the requirements were not met. However, because these two requirements were not met, you remember that they do qualify for a deduction, which ultimately reduces the estate of the deceased. So that was a quick snapshot of what would happen to the proceeds from an estate duty perspective. Like I said, the video was not based on doing the actual estate duty calculation, but just to show you the effect of policies that are paid under a scheme of business assurance. Now, like I said, in terms of applying or interpreting the actual legislation, sure, some of the things are this way or that way. Give you an example. That premium deduction I just spoke about, the 600,000 rands, sorry, the 100,000 rands for policy number 2, which is the key person, and the second policy, which is 100,000 rands for the contingent liability. That deduction is said to, you can increase that premium of 200,000 rands in total by 6%. Now, the Act doesn't go into detail whether it's compound interest or simple interest. However, based on my research, I found that the SARS practice is to actually use a simple interest. However, there's no formal documentation or authority that actually says that. And that's the kind of stuff that I go into the dissertation. So although there are some gray areas, but however, just through looking at how you structure the policy alone, you could mitigate certain conditions. And obviously, depending on the facts of your clients, you could make sure that just by structuring the policy alone, things are going to pan out the way that you intended them to. And remember, the other thing is, and this is the portion that I'll go into dissertation in detail, and I'll probably do another video on it. If the policy does attract state duty, although we don't know how much a state duty will be attracted by that policy, in our case, the key person policy and the contingent liability, from a policy perspective, we can increase the cover so that we can factor in that estate duty liability, so that the estate duty liability comes off and the client is still left with the 3 million rands requested for the key man policy or the 3 million rands requested for the contingent liability. So there are other solutions that I'll be getting into later on, which is just really a solution that provided by the financial services industry through the use of life policies. It's not regulation or anything like that. I hope you enjoyed the video, and I hope it gave you a quick introduction of how estate duty is treated. On the next videos, we'll be dealing with the other taxes in a bit more detail, especially with the key person policy. There's some income tax considerations to be made there as well. Anyway, see you soon. Thank you.